Hey guys, welcome to my legal classes. This is Ganesh Pujari and we were discussing essentials of valid contract, and in that we have discussed free consent as the second element in my previous video in brief, and in this session I am going to discuss one important section of free consent, that is coercion, and I'm also touching upon duress, which is the concept of England, which is quite equivalent to coercion. So I have named this video as video 3A because this is coming in the series of free consent, and let us try understand the concept of coercion in detail in my next two slides. Before getting into section 15 of the Act, which discusses about coercion, it is very important for us to understand the dictionary meaning of coercion. Coercion is the action or practice of persuading someone to do something by using force or threat. Now, somebody doesn't want to do something, but by using force or threat, if you want or persuade them to make something, then that is known as coercion. Now, section 15 says, and I read, coercion is the committing or threatening to commit any act forbidden by the Indian Penal Code, or the unlawful detaining or threatening to detain any property to the prejudice of any person whatever, with the intention of causing any person to enter into an agreement, is coercion. Now, what are they bringing? They are bringing four important elements, that is committing any act forbidden by IPC, or threatening to commit any act forbidden by the IPC, and unlawful detaining of any property or threatening to detain any property unlawfully. These are the four concepts we need to understand, which I am going to explain with the case laws. Before that, we need to remember that it is immaterial whether the Indian Penal Code in force in that particular place or not. That is not important. It is immaterial to that extent whether IPC is in force or not in that place. Whether or not, if it is in force, the coercion section will definitely apply, and we are going to understand the four important elements one by one. First being committing any act forbidden by IPC. What are the acts forbidden by IPC? The few examples for the acts forbidden by IPC can be kidnap, abduction, murder, grievous hurt, rape, etc. And if somebody by committing those acts forces or threatens someone to come into an agreement or contract, such contract are not valid as per section 15. That is all you need to remember when it comes to the committing of any act forbidden by IPC. It is not necessary that someone has to commit any act forbidden by IPC. If someone is threatening to commit, then that is also considered as coercion, which is my second point. And for that, I have two beautiful case laws. The first case law is Chikam Amiraju versus Seshamma. What happened here? There was a husband and wife and a son, and husband gives a suicidal threat to wife and son, saying that if they don't execute the property document in favor of his brother's wife, then he will suicide. This is an offense which is forbidden by IPC as per the section 309, and the contract is voidable with the option of wife and son. The second case law is Ranganayakama versus Alvar Sethi. What happened here? There was a widow of 13 years of age, and someone threatened her, saying that if she is not adopting a kid, then her husband's dead body will be pulled out from the cremation land. So with the scare of that, she came to a contract which is considered as coercion, and such contract is not a valid contract. The third aspect is unlawful detaining of any property. If somebody is unlawfully detaining anybody's property for the purpose of contract, that case it is considered as coercion because there is absence of free consent. Now, this is discussed in Mutaya versus Muthukaruppa case law, where a person hired an agent for the purpose of maintaining the accounts of his business, and one fine day he wanted to change the agent, and he called the agent and told that he will be changing the agent, and before changing he asked the agent to give all the documents back to him. Now the agent said he will not give any of the document unless and until he clears all the liability from the agent, and it was held that such action by the agent is coercion and not valid. The last aspect that we need to learn here is threatening to detain any property unlawfully is also not free consent, or it is considered as coercion. What happened here in the case law of Hansraj versus the Secretary of the State, a son had to pay some fine to the government, but he was unable to pay. So what the government did, the government of India threatened his father, saying that if he is not paying the fine, then they will take all the properties or they will attach all his property. So the father got scared and he paid all the fine of his son. Now it was held in the court that such action from the government was coercion because they threatened the father that they will attach his property. So that was not a valid threaten, or that is not a way that government of India should act it. So it was held that it is coercion. With the help of this slide, let us try understand a little more information about coercion, and let us also try understand the concept of duress. Now, section 19 gives voidability of agreements without free consent option. Whenever there is a consent taken via coercion, fraud or misrepresentation, such agreements can be voidable with the option of the party which was being the consent was so caused, or to whom such consent was made to be arrived. That is possible as per section number 19, which is about voidability of agreements. Now, coercion need not to be direct always. It can be indirect also, by threatening someone else from your family. If somebody is making you to sign a document, then that is coercion. That is what you need to understand. And if there is a threat to file a wrong suit against you, that is coercion. However, threat to file a case itself is not a coercion. If there is a false charge is been threatened, then that is coercion. However, if somebody is saying that they will file a suit against you, which may be a civil or criminal, that is not a coercion unless and until it is made with the false charge. Now, if somebody is threatening to commit suicide, then that is considered as coercion, and the person threatening need not to be the principal person. It can be done by someone else also. Now, for example, if I want to make you to sign a document, if I am threatening via some agent or someone else, in that case, that is also considered as coercion. It need not to be done by the principal person himself. The benefit received by coercion should be returned as per section 72, which we are going to learn in detail in my future videos. And place of coercion doesn't make any change, because section 15 very clearly spells out that IPC's force in that particular place doesn't matter. Whether IPC in force or not, the coercion component will be a matter which makes a contract invalid contract. Detaining property under mortgage loan is not a coercion. That is the way mortgage loans are dealt. So till the payment is made, the detaining of property under mortgage loan is valid and it is not coercion. But if someone makes such detaining even after the payment of mortgage loan, then that is coercion. While we in India use the term coercion, in England the term duress is utilized. Now, there is a lot of similarities between these two, and there are few important differences also, which I am going to explain. Before that, let us try understand the term meaning of duress. Duress is wrongful pressure exerted upon a person in order to coerce that person into a contract that he or she ordinarily wouldn't enter. Here there is a coercion, there is a wrongful pressure put upon a person to ensure that he is coming to a contract. And the biggest difference between coercion and duress is coercion speaks about both the acts forbidden by IPC and detaining or threatening to detain properties, whereas duress is all about bodily violence only. There is nothing about properties. The second biggest difference between coercion and duress is coercion can happen with the interested party also, whereas duress happens only with the person's life and liberty, or max to max it can extend to family members. Nothing more than that can happen in the case of duress. And the last difference is, in duress there is presence of immediate violence, whereas in coercion there can be violence or there can be absence of violence also. And these are the three important differences between coercion and duress. That brings an end to our discussion on the topic of coercion, and in my next video I am going to discuss in detail along with case laws about the undue influence aspect. All the very best for whatsoever purpose you are watching my videos. Please subscribe my channel, please like, share and comment my videos, and thanks again for watching me.